Now, the Daily Telegraph has published details of allegations of sexual harassment, racism and bullying made against Sir Philip Green. It's after the Topshop owner ended legal action against the paper. Sir Philip strenuously denies any wrongdoing. Well, specialist employment lawyer Matt Gingell joins us from South London. Thank you for joining us this afternoon. So the non-disclosure agreements signed by the accusers are very much in place. Exactly what are they, and are they legally binding?
Well, non-disclosure agreements, which are commonly known as settlement agreements, are agreements where normally employees or ex-employees waive their rights to bring claims, and they normally get a payment. And there's normally a clause in these agreements that they abide by confidentiality obligations, and therefore that the terms and the background it remains confidential.
What are the consequences for breaking that clause?
If employees or ex-employees break these clauses, then the employer could sue for damages for breach of the obligations under the agreement.
And presumably how much the employer sues varies from case to case?
Yes, and it depends on, obviously, the terms of the clause and, what the damages could be. It's important to stress that there are some exceptions about disclosing. So these confidentiality obligations, for example, can't exclude people from going to the police or from reporting wrongdoing to regulators. So there are some exceptions.
To what extent are these NDAs something that is particularly for the rich and powerful? Because I guess that is the perception. Is there a truth in that, or is that very much a myth?
I think these NDAs or settlement agreements are used widely across the board, really, from for small businesses to large employers. And they're obviously agreements that employees and employers enter into, and they need the employee needs independent legal advisor as well to go through the agreement. So they're not something that employers, would push employees to sign without them having legal advice.
Are there any examples where these NDAs have been broken and an employer hasn't been able to pursue legal action against the accuser?
I'm not aware myself of any particular examples, but obviously, there will be cases where employees breach those obligations, and employers do take action. Obviously, there are clauses in the agreement which often may not necessarily be enforceable, which often uses a deterrent for people to not go to the press or to third parties. So there are, these clauses do exist, and obviously there will be occasions when they're breached.
And just give us a sense of how the process works in order to get these NDAs signed. Who signs on the dotted line ultimately, and who gives a green light that they can't be breached?
Well, it would be the employee and their lawyer that would sign the agreement, and then the employer would also sign. So it would be employee, employer, or ex-employee, and the legal advisor. And the legal advisor's obligations have specific statutory obligations to go through the terms of the agreement and also explain the person's inability to pursue employment claims. So it's very strict that the solicitor or legal advisor has to go through the terms of the agreement and explain very clearly all the implications.
And what about if the accuser decides to go overseas, gets a new job abroad? Does the NDA still apply if they're in another country?
Well, I'm not sure about all the different jurisdictional laws, but certainly if an agreement is signed here and it's governed by UK law, for example, then obviously the UK law would apply.
OK, Matt Gingell, thank you for your time. Thank you.
All right, thank you.